Namaste. Welcome to the Atharva Forum. Today we have with us Advocate Kanu Agrawal to discuss a very important subject related to free speech. Before I proceed, I request everyone watching to subscribe to the YouTube channel and also press the bell icon. So to discuss the subject, we have with us Advocate Kanu Agrawal. He's a practicing lawyer at the Supreme Court of India. He's currently on the panel for the Union of India. Just to set the context, in the popular media as well as in academia, we've been hearing a lot that, there's a huge threat to free speech and dissent, in the post-2014 era especially. And, just to support this claim, numerous instances of, internet shutdowns, requirement of standing up for national anthem, government's inaction on communal speech, these instances are highlighted. But this subject is nothing new, to our courts or to our governments. We've been having such issues, since way back. So in today's conversation, basically, I would like to discuss the historical context behind attitude towards hate speech, especially discussing the cases about Rangeela Rasool, about the different publications that came out around that time and how the British courts as well as the governments dealt with the subject. Because in my view, more often than not, we see that the courts are deciding these subjects, keeping in view political considerations rather than applying, the legal standards. And this is something which continues to this date. So, we can just start with the discussion and then also go into the history of how the provision of Section 295A, which is always at the center of these cases, this came about, how the British government came up with this law. Because, of course, the Section 295A is effectively like, against blasphemy. So to start with, in the 1920s, there are several literature that came about, like Rangeela Rasool, like Vichitra Jivan, like Risala-i-Vartman. And they caused a huge public order issue for the government of the day. And also they reached the courts. And the decisions that came about from those courts were very significant. And they still, but ironically, in today's conversation, the jurisprudence that came out from those cases is not, remembered as such. So I would like you to start with the case of Rangeela Rasool and how the judgment given in that court is significant even today when it comes to balancing free speech and public order.
I'll dive into the topic directly. While studying legal history, it is very important to understand what is the social context in which those legal developments took place. Because see, the law and its precedents, they don't exist in a vacuum. Therefore, especially while studying the history of controversial cases, it is important for us to note the social context in which they propped up and how the other organs of the state, that is the executive and the political class, actually received the opinions of the courts. Because this legal history itself always is an evolving subject. The court gives an opinion, thereafter the political executive or the politically elected leaders respond to it. There are numerous cases wherein the political executive or the legislatures have taken away the basis of judgments and reacted to particular sort of interpretations, much like the First Amendment of the Indian Constitution. Therefore, to understand Rangeela Rasool, we need to first understand the social context of the 1920s India, which, again, ironically has an eerie similarity to some of the developments that have been taking place in 2020s India. It's almost as if history is repeating itself after exactly 100 years. So at the start of the 1920s, what we study is that there was a Khilafat movement which took place in conjunction with the otherwise secular non-cooperation movement. Now, the Khilafat movement is the movement that actually laid the foundations of the two-nation theory, and that has been well documented by historians on actually all sides, that it was the Khilafat movement where the Muslims of the subcontinent chose to protest against the British for deposing the Ottoman Caliph, while their Hindu brothers were busy in the secular movement of independence under the Congress banner. Therefore, pursuant to the Khilafat movement, the idea of Islamic nationalism was taking place in India in the 1920s, which was largely taking birth out of a phobia of being governed in a democratic system wherein Hindus would constitute the majority. In conjunction with this, there was a Hindu revivalist movement, although to state that Hindu revivalist movement really started in the 1920s would be wrong. However, I would say that the Hindu revivalist movement had gathered a significant amount of pace during the 1920s with the work of Arya Samaj, things like this Shuddhi movement really having a socio-political impact on the developments of the day. At the same time, interestingly, and you can draw a parallel with social media today on this point, is the birth of the Indian printing press. post the 1910s and the 1920s, there was a large proliferation of the printing press in India, which was leading to various kind of publications. And obviously, it is always said that as soon as the power comes in, like today's social media, there were various publications by communities against each other. And in fact, owning a printing press in that era used to be an important symbol of power, because that was the only means through which you could impact the minds of a larger populace. Considering these factors, for these three cases, the flashpoints became the undivided Punjab and United Provinces, which we refer to as Uttar Pradesh. These three publications that you have referred to have been documented in detail by British historians and unfortunately ignored by Indian historians, which ultimately led to the passing of Section 295A, as you have noted. The three cases are Rangeela Rasool, Vichitra Jivan and Risala-i-Vartman. The most important of this is undoubtedly Rangeela Rasool, because largely the other two cases which followed Rangeela Rasool were an attempt and a reaction, as I was referring to, by the political executive to ensure that the decision in Rangeela Rasool doesn't sustain the test of time. So the story of Rangeela Rasool starts in 1924, where a Hindu proprietor and a bookstore owner in the name of Mahashay Rajpal had allegedly printed a scurrilous pamphlet which was titled Rangeela Rasool. Now, as the name of the title goes, the pamphlet brazenly discussed the intimate relationships of Prophet Muhammad, and it led inevitably to a public order situation. It is important to note actually that Rajpal maintained the anonymity of the original author of the pamphlet in an era where anonymity really didn't have a lot of value. Again, I would draw a parallel with social media today. But he maintained the anonymity and he took the blame himself, that he ensured that he never revealed who the actual author was. Different historians of the times have referred to who could be the authors. However, that may not necessarily be relevant for our discussion. As I said, that this particular publication enraged the Muslims in undivided Punjab, and this led to communal tensions between Hindus and Muslims. There were widespread Muslim protests and agitations which alerted the then undivided Punjab's government, and even the governor, who was Governor Haley at that time, recognized the severity of the offense and noted the text in the pamphlet. Obviously, the reaction of the governor led to Mr. Rajpal being charged under 153A of the Indian Penal Code, which existed in the Penal Code at that time, in the absence of Section 295A. It specifically dealt with promoting enmity between different groups on grounds of religion. The case, after the investigation was over, as is the case in criminal investigations in our country, went to the magistrate. The magistrate found Rajpal guilty. The prosecution argued that an attack on the Prophet or a satire on the Prophet could only be viewed as an attempt to promote feelings of enmity between classes, and therefore he is guilty of Section 153A. Rajpal pleaded not guilty. Rajpal said that actually this pamphlet is published in aid of removal of social ills such as concubinage, temporary marriage, polygamy, and gross disparity of age in marriage amongst the two communities. He further said that the allegations in the pamphlet are true, which takes it to Section 499 of the IPC, although that's a debate for a separate time, that truth is actually a defense. And he sought to establish by fact that they were actually based on works by Muslim and European authors on the subject. The learned magistrate ignored both these defenses. He said that this is a wanton attack on the Prophet of Islam, to hold him up to ridicule and contempt, and to ridicule the religion as a result, and therefore he has wounded the feelings of its followers, and therefore he is guilty of Section 153A as the natural consequence of his speech. And this is where the line is to be drawn, and this is where the subtlety in free speech jurisprudence lies. The approach of the learned magistrate was that the natural result of the publication was that it would result in incensing the Mohammedans against the author of the book, against whom they conceived to be rightly or wrongly as sympathizers of the author. Therefore, merely because something satirical is published by one person, the learned judge comes to the conclusion that it will lead to tensions between both communities and not just the author and the community. The court said that his defenses in the nature of truth and his defenses in the nature of reform are not enough mitigating factors, and therefore convicted him to a rather severe sentence at the set time of 18 months, along with a fine of rupees 1,000, which is also pretty severe if you see it from the point of view of 1920s India. The Sessions Court upheld the conviction and reduced his sentence to about 6 months. And interestingly, Sessions Court noted something which sort of again rehashes in the future, where today the courts are entering into the arena of hate speech and almost by way of a judicial imprimatur seek to stop the speech of people without there even being an interference by the political executive. The learned Sessions judge notes that the offense against him that is alleged, against Rajpal that is alleged, is reprehensible and dangerous, and that's fine. However, then he notes, and what I can only term as judicial chilling effect, is that it is necessary to both punish him and deter others from similar acts. So the court lays the foundations under 153A to make Rajpal the example, to ensure that others from the community do not commit such acts. The case obviously was a extremely heated case. The Rajpal was a noted Arya Samaji, and he took the case to the Lahore High Court at that time. Justice Dalip Singh of the Lahore High Court delivered the landmark ruling in the case, which according to me has been forgotten both legally and historically in this country. Justice Dalip Singh made two extremely subtle, however important distinctions in free speech jurisprudence. Justice Dalip Singh said that it is undoubted that the pamphlet Rangeela Rasool constitutes a satire on the founder, and it's a scurrilous attack on the founder of the religion. However, he states that merely attacking the founder of the religion would not ipso facto bring a particular aspect of speech as an attack on the religion as a whole. Now, this is a subtle distinction which subsequently in both the other cases, one from Punjab and UP, has been ignored, and has certainly been ignored in independent India. The other aspect is that the government advocate argued something which has now become almost both the legislative and the judicial test, that it is not the content of the speech that matters, rather it is the consequence of the speech that matters. Therefore, I may say something which may per se in content not be that harmful or may not be that aggravating. However, if merely because of the sensibilities of the other side, or for that matter, the lack of sensibilities of the other side, results into a public order situation, my speech is liable to be curtailed. And on the other hand, if the other person says something which is clearly a scurrilous and wanton attack on the other religion, however, because the sensibilities of the other religion command or respect free speech in general, there will be no public order issue, and therefore there will be no action against free speech. So it was in Rajpal's case in the Lahore High Court which really laid the foundation of this, and the government advocate argued that because the Mohammedan community, and I'm quoting this so that I'm not really taken out of context, that because the Mohammedan community is more fanatical on the question of religion than other communities, a satire on the foundation of the religion is more likely to promote hatred and enmity between classes than a satire on the foundation of another religion than like Christianity. Now, according to me, it's an extremely serious and an extremely erroneous argument by the then government advocate, because for the simple reason that merely because there are different religions, there cannot be that the state adopts a different standard of free speech. Justice Dalip Singh almost immediately and correctly rejects this argument and says that ignorance or fanaticism of a particular community cannot determine the nature of the act, therefore laying the foundation of the content test as opposed to the consequence test. Justice Dalip Singh actually warned against this line of argument in his judgment, and he states that the nature of the act, whether it is an offense or not, cannot be determined by the reaction of a particular class, which is exactly the point that I was making. Now, this finding as the test has been ignored. Both the legislature in enacting 295A and in fact even 153A and the courts in the future have completely ignored this, despite there being considerable development in the jurisprudence surrounding free speech. The courts have ignored that it is the content of the speech which shall remain the test, and it is not the consequence that should matter. Justice Dalip Singh on the applicability of section 153A, qua Rajpal and his publication in Rangeela Rasool, had that the section never intended people from making attacks on a particular community, or it was not there to stop normal satire on religious leaders, however bad in taste it may be. He held that speech may well wound the followers of a particular religion, but it would not, if it is not leading necessarily to promoting elements of hatred between communities, it cannot be criminalized under 153A. There may be other actions that you may be able to take under maybe tort law, or you may file a suit or other things. However, to criminalize speech, you would have to establish that it necessarily leads to feelings of enmity and hatred. And on this ground, Justice Dalip Singh acquits Rajpal. and draws a rather tasteful distinction between distasteful content, which may even include an attempt to incite a particular class, as opposed to promoting enmity or hatred between classes. Now, this is something that the Indian Supreme Court has noted in the context of Section 124A. However, the court has really not noted it in the context of Section 295. This fine distinction has really been sort of lost ever since the judgment of Justice Dalip Singh. And one must not forget that this is a judgment rendered in the pre-constitutional era. This is not a judgment rendered in the great constitutional era of free speech and Part 3 rights. This is a judgment rendered purely on the statute book. This is a judgment rendered dehors of any constitutional provisions. So, according to me, it's a remarkable judgment, and it is extremely sad that how both of us come from decent law colleges and we are still not taught this. We are taught all the judgments from Indian Express to Tata Press to Romila Thapar and everything on free speech, but we are not taught the judgment of Justice Dalip Singh, and it really makes us wonder what is the problem. So, this judgment, and if studied in the context of the socio-political context that I had described, really leads to a fallout. It leads to a fallout in terms of how the British viewed the relationship between the two communities. We have to understand that the British and their understanding of two communities is very different from, say, what the two communities themselves would understand their relationship with each other. The British, after being hurt in what had happened in 1857, had almost openly adopted a policy of don't ask, don't tell, and of not interfering in personal affairs, which led to ultimately enactment and recognition of personal laws on the basis of religious sensibilities of both communities, and so on and so forth. Now, because this was resulting into a serious public order situation even after the judgment, it was again Governor Haley who publicly noted that there is a serious danger of disorder in view of judgment of Justice Dalip Singh. He reacted to the judgment of Justice Dalip Singh, and he said that an attack, this is the governor, the British governor, stating that the attack on the Prophet is a concrete offense against Islam. And in light of the judgment rendered by Justice Dalip Singh, this could be repeated and it could lead to another public order situation. Almost again, we have seen the rehash in recent times. After the judgment of Justice Dalip Singh, Rajpal was acquitted. However, unfortunately, after several unsuccessful attempts on Rajpal's life, he was stabbed to death by a virtual commoner, a carpenter by the name of Ilmuddin, on the 6th of April 1929. Ilmuddin was unsurprisingly sentenced to death in the same year itself. What is important to note, according to me, is that what happened in terms of how the community took the actions of Ilmuddin. It would be normal for any community to deride the actions of a person who has been convicted to death by due process of law. However, that was not the case here. Ilmuddin was represented by perhaps the most prominent lawyer across undivided India in the form of Muhammad Ali Jinnah, who must have, according to me, traveled all the way from Bombay to Lahore, largely on a pro bono basis, because I don't see Ilmuddin or his family affording to pay Jinnah's fees, who must have been, again, one of the costliest lawyers in the country at that time. He represented him, although unsuccessfully, because it must have been a case of a clear conviction. And secondly, the poet extraordinaire at that time, Sri Allama Iqbal, was the person who actually read his Namaz-e-Janaza. And it is said, and by authors, different authors, that Allama Iqbal was in tears when he was putting his body to rest. And he said that this young man has left us, the educated men, behind, as if to almost instigate the educated people that it was actually an uneducated man who defended the faith and not the educated ones. Now, this is sort of unsurprising again, that he was given titles of Ghazi, he was called a great Shaheed, there were parks named after him, and he still, from my research, remains a hero in the streets of Lahore. Now, these incidents have consistently happened in Indian history. One of the major writers, I would say, of the said time was B.R. Ambedkar. And it is interesting that although in the context of him criticizing Gandhi, which was perhaps his favorite pastime, he notes these incidents and he even refers to Rangeela Rasool. And he notes that this has been happening far more frequently than anyone has noticed. And he says that, and again I will quote, that the murderers paid the penalty of the law where it was enforced, and the leading Muslims of that era never condemned these criminals, which is a question that I seek to ask today. Even in the case of Rajpal, Ambedkar said that most of these criminals were hailed as religious martyrs, and that agitation was carried on for their clemency, and it was said that some reasonable attitude be shown towards them. So I ask myself that what is this ultimately is an extra legal imposition of Sharia sensibility, if not through the law, then through extra legal means. So I guess this is where the story of Rajpal ends, but it still lives through us because we lived through the same times and we lived through the same events that keep happening in this country again and again.
Absolutely. I mean, this judgment should have been one of the foundational principles for our courts in the post-independence era also. But sadly, I mean, you're right. Whenever we read the literature in all our reference books or even our history books, don't seem to mention this case. While we are discussing the case of Rangeela Rasool, it's also important to discuss the two other publications which came around that time, like Vichitra Jivan and Risala-i-Vartman. And how do you see the comparison, like the way the courts reacted? I mean, the courts and the governments reacted to Rangeela Rasool and how they reacted to, the other two publications.
See, as I said, with the reaction of Governor Haley post the judgment of Dalip Singh, it was very clear that the government was all out for ensuring that the foundation of this judgment is taken away. If they didn't say it publicly, they were effectively waiting for another case to come for them to prosecute it in a different manner and to ensure that the foundation or the legal jurisprudence laid down by Justice Dalip Singh is taken away. Which takes us to the case of Vichitra Jivan, which was happening in a different province, in the United Provinces in Uttar Pradesh. Now, Vichitra Jivan was published in 1923, again a similar satire, and we have to understand that these things, as I said, were happening in 1920s in a very common manner. It was not as if that only one side published publications against the other. It was rather a two-way affair, and in fact, mostly instigated by the other side. In fact, even Rangeela Rasool, it is said, was in response to the depiction of Sita in a particularly derogatory manner that Rajpal and the original author of the pamphlet had responded to. Now, Vichitra Jivan, as I said, was published in 23. However, it didn't really catch the public eye till the Rangeela Rasool case. So it was only in 1926, when the Rangeela Rasool case had already reached the courts, that the government reacted to Vichitra Jivan. Now, government reacted to it in two forms. At the said time, the Code of Criminal Procedure had a provision which still exists of forfeiture. That in case a particular publication is leading to a public order issue, in case it commits an offence under 153A, the government holds the power to forfeit it. The provision may have become unworkable in today's days of technology, but the provision at the set time under section 99A of the then CRPC existed. So the government moved on both counts, one on the criminal count and the other on the civil count. First forfeit and then convict the person. The case first came to the Agra District Court, and the defense actually took the case directly to the Allahabad High Court, which at that time also had original jurisdiction. Vichitra Jivan was again authored by an Arya Samaji preacher by the name of Pandit Kalicharan Sharma, and loosely translated, the title itself says Strange Life, and it was referring to the strange life of the Prophet Muhammad. The claim by the author in the case of Vichitra Jivan was that the primary object was to merely contribute to the Shuddhi movement and to aid the reclamation process and to ensure that people don't leave the Hindu fold, which still remain to be the open goals of the Arya Samajis. Now, on the issue of injunction or forfeiture in the CRPC, the Allahabad High Court, and perhaps rightly, and I'll draw the distinction sometime later, perhaps rightly held that the inevitable consequence of the book was that it led to excitement of enmity and hatred between the followers of the religions, and therefore it is liable to be forfeited. However, it is in the criminal proceedings that the court applied the same standard. It was first the magistrate who ruled that Sharma was guilty under 153A, and again a sentence of about 1 year and 1,000 rupees was imposed, almost similar to the Rajpal case. In appeal, it went to Justice Dalal, who delivered his judgment in 1927. and clearly marked a difference from the Rajpal case. It was almost as if the Rajpal case was really in the background and it was really working on the heads of everyone, that it has, that this case is a test case for us to take a different view from what Justice Dalip Singh did in the Rajpal case. The court, as I said, adopted the consequence test and ignored the content test. And it said that as per a layman's perspective, the content is clearly scurrilous. It will lead to a public order situation. It made the layman's perspective the guiding factor and ultimately upheld the sentence by reducing it to 6 months. So the story ends here. I'm not really a history researcher per se, but I'm not able to find any kind of violence that was committed, thankfully, against Mr. Sharma after his conviction. The next case was again the case in Punjab, where the government almost openly came out to seek an overruling of the judgment in Rangeela Rasool. Again, in this case, in Risala-i-Vartman, the government took the twofold approach. One was forfeiture and the other was prosecution under 153A. The article was concerning Sair-e-Dozakh, which can loosely be translated to a trip to hell, which was published in this journal, Risala-i-Vartman. This caused considerable excitement again in the areas of Amritsar in and around 1927. And in response to this, posters were distributed amongst the public, attracting attention towards the journal and ensuring that it causes hatred amongst the communities. The government ignores the other pamphlet, which calls for action, and rather seeks to prosecute the original publication. Same story goes. The publisher by the name of Gyanchand Pathak and the editor by the name of Gyanchand Pathak and the publisher by the name of Vichitra Sharma, both convicted under 153A. The Lahore High Court, after the magistrate had convicted both these people, held that the article is in extremely bad taste. It is scurrilous in nature. It is a disgusting satire on certain incidents in the life of Holy Prophet. The court then held that words employed are such that they would, in ordinary course, create hatred between enmity in the minds of people. It held that it seemed difficult to distinguish an attack on the founder of a religion from an attack on the religion itself. This is the distinction that, as I had noted earlier, Justice Dalip Singh had noted, that an attack on the founder may not necessarily be an attack on the religion, which would inevitably lead to a public disorder or which should lead to promoting feelings of enmity between classes. However, the judges really mix it up in this case and say that it is not possible to distinguish the two. They clearly adopt a different approach and again convict both these people. Again, the test adopted was a consequence test. The state had led evidence this time. It was better prepared. And the evidence was in the form of 12 or 15 common men who deposed, saying that I have read the contents of this particular article and it had really incensed me, and I think that it will lead to a situation where hatred is promoted between two communities, and therefore criminal liability should be foisted on Gyanchand and Sharma. Therefore, with this court adopting the consequence test, we land up in a situation where criminal liability in the context of free speech is foisted on a person, not even on the general sensibilities of the public at large and not even on the content, the real content of the speech. Rather, it is foisted on people by the prosecution by picking up 10 or 15 good men and making them depose whatever they wish to in favor of the prosecution. And it is impossible to even cross-examine such witnesses in a case where the test becomes the private sensibilities of a prosecution witness, and not even a witness per se in a criminal trial is to depose on a matter of fact. A witness is not supposed to depose on a matter of opinion. A matter of opinion is dealt with separately in the Evidence Act. In any event, the application of the law in both the subsequent cases, largely at the instance of the government and with the social political developments that were taking place in both these states, really hurt the development that had taken place by way of the judgment in Rangeela Rasool. And it also rendered the progress towards free speech, which was being pushed by various other authors of the era during the time, really to the sidelines, as the state had consistently failed to protect people who had upheld free speech, and B, secondly, sought to prosecute the people who had sought to write what some may say as distasteful content, but with an element of truth or with an element of self-defense. With these two cases, I guess, at least as per the political accounts, the overruling of the Rangeela Rasool or the Rajpal case was complete, and it led to assuaging the feelings of a community at that time, which had really organized itself as a political entity across the continent, obviously as a consequence of their support to the Ottoman Caliph and the Khilafat movement. And as I've already said, B.R. Ambedkar noted it in great detail and criticized the general view of even the prevalent or the popular Muslims at that time, that the perpetrators of such violence have not really been condemned by the community. It is something that perhaps the times have not changed. It is almost ironic that when the same things happen and they repeat itself almost every year, whenever someone says something, it is almost as if people like you and me can sit and just wait that the events that happened with Rajpal will take place again, and the state will again fail the person who had merely sought to speak something which may actually be true by most accounts.
You're right. Like such cases are repeating themselves in the recent years as well. But before I come to them, because there are several cases that have happened in the last 2-3 years where similar killings have been carried out. I do want to I would like you to spend some time describing how the decisions coming out of these courts shaped the understanding of the British government on how to regulate free speech and how it led them to enact this particular section, section 295A.
See, as is clear that Governor Haley at that time was a pretty influential man. That's why he was given the charge of perhaps the most important state in British India at that time, which was undivided Punjab, which was itself a melting pot of cultures at that time, with the influx, with almost the population one-third divided between the Sikhs, Hindus, and the Muslims. So, because he was such an influential man, the direct consequence of these particular cases was that the British realized that there is an impending need for a section in India, considering the lower religious sensibilities of the people here, to enact a specific provision to deal with this. To enact a provision which seeks to criminalize speech whenever it is sought to attack a particular religion. And obviously, the words attack a particular religion have been interpreted in extremely wide terms. The British first drafted a bill, sent it to a select committee. The select committee published its report on the criminal amendment bill. The criminal amendment bill was in public domain. It was discussed in great detail. It was discussed in the then parliament. It was discussed in public debates as well. And it was heavily criticized. At least the earlier draft was heavily criticized. Thereafter, the select committee made some important changes. It adopted a balancing approach. It ensured that the provision was not so widely worded that it would attract criminal sanctions even in cases where, say, an attempt for reformation is made or even a fair comment is made. And in typical British style, they introduced three extremely confusing provisions, three extremely confusing words in the provision, which were with deliberate intention, and linked it to an attempt to attack the community in any form, but only with a deliberate intention. Therefore, as per the select committee, these words sort of lowered the threshold. These words sort of protected the application of the proposed section in the form of 295A in the manner that it would not lead to conviction of people who were otherwise innocent or which never with deliberate intention sought to attack other religions. And I guess in this way, perhaps almost by a British diktat, with some debate and some criticism and some fancy select committee of the British, 295A, for better or worse, became a part of the Indian Penal Code.
Yeah, and it continues to be.
Approach was adopted, and 295A was subsequently, to my recollection, upheld by the Indian Supreme Court by 5 judges in Ramji Modi's case on the basis of the report of the select committee, which was cited in the case by the government, and with the interpretation that these words with deliberate intention ensure the constitutionality of the provision and ensure that this is merely a reasonable restriction on free speech. However, in application, it has not really resulted in the same manner as the Great Constitution Bench would have envisaged. And this way, 295A still remains on the statute book. To my recollection, it has been consistently been applied against various people. To my recollection, it was applied against Mr. Sitaram Goyal as well.
Yes, the section continues to be relevant, and it is always, interpreted in a completely different way. As opposed to the way justice saw it, in the Rangeela Rasool case. Let's move on to some cases of the recent years and just try to examine how the response of the community which claims their religious sentiments are being offended, how they have responded, in the recent years, and how they have responded in the last century. So the most brutal example that comes to mind is the killing of Kamlesh Tiwari that happened in 2019. For years, I mean, he was under threat. There was a clear threat, against his life, but he didn't receive any state protection, and eventually was killed because of because of something that a community feeling that their religious sentiments are being hurt. So, can you walk us through the background of this case and how the state authorities have responded to, the case of Kamlesh Tiwari?
Kamlesh Tiwari is almost history repeating itself after 90 years. And what was surprising is how the state had reacted during this sad time, especially with Mr. Tiwari and the approach that it had adopted. It is almost as if that the independent Indian state took a far more graver view of the incident than what the British did in that era, in the 1920s, in the pre-constitutional era. So the case of Kamlesh Tiwari, according to me, starts in 2015, when the then finance minister, Mr. Arun Jaitley, made statements in support of decriminalization of homosexuality, to which a prominent politician of the Samajwadi Party made a response to and made certain distasteful remarks against the RSS. In response to the comments of the leader of the Samajwadi Party, Kamlesh Tiwari made certain distasteful remarks against the Prophet. Now, this is a to and fro which keeps happening in politics. I would rather not go into it. However, it is again, I use the same words, it's a rehash of history that about 1 lakh protesters, as per again contemporary records, 1 lakh protesters gathered in Muzaffarnagar and demanded death penalty for Tiwari as soon as these statements were made. Tiwari was first arrested and charged under 153A and 295A, because now it exists in the statute books. Now, what was surprising was the next step of the Indian state, because 153A and 295A were even used in the previous era. The Indian state preventively detained Kamlesh Tiwari. The Indian state exercised the powers under the National Security Act, which can purportedly only be used against people who are acting in a manner which is prejudicial to the defense of India or relations of India with foreign powers or the overall national security of India. That's why it's called the National Security Act. And for something like this, Tiwari was detained under the National Security Act for more than a year, and the case was not even being heard. It was only after the prodding of the Supreme Court in a writ petition that the Allahabad High Court ultimately quashed the detention order, which is ex facie unsustainable, or in 2016. And I know if it is the correct thing to say again, that there were calls for state protection, and I always say that the imposition of the National Security Act was actually state protection for Mr. Tiwari, because perhaps that was the only way to keep him alive with the kind of response that there was. In any event, he was released in 2016. The man lived for full 3 years after that. He was far luckier than Rajpal, I guess, because Rajpal was killed the year after that. So in 2019, Tiwari was murdered by two assailants who were claimed to be inspired from ISIS. The investigations are still going on. It is said that these people arrived in saffron kurtas with a sweet box, and he was shot and then stabbed 15 times. Now, the difference in approach is, as I have already highlighted, the difference in approach is that the independent government chose to, over and above 153 and 295A, chose to adopt the approach of preventive detention, chose to preventively detain the person under draconian provisions, And despite calls for peace and security by other members and by people seeking protection of Mr. Tiwari, no such protection to my knowledge was given to Mr. Tiwari. And what is consistent across these cases is the extra legal, the coercive, the violent imposition of Sharia sensibilities, where it is said in Hindi, I don't know how many followers of ours really follow this mix of Hindi and Urdu, that the chant is Rasool se gustaki ki saza kya, sar tan se juda, which basically means that if you disrespect the Prophet, the punishment for that is only one, is that your head will be severed. So I think that is something that has remained consistent across the two cases. And the difference is that the Indian state, despite it being this democratic, this state based on the ideals of constitution, has really not been able to protect free speech in terms of not just imposing criminal liability. I'm not on criminal liability here. Maybe Tiwari was guilty under 153 and 295A. Those cases will have to be argued on merits. They may have abated now. But what the Indian state failed in was the simple issue of protecting a person and his life and liberty. So these are the cases which are happening today. I see the same thing repeating in Gujarat, which we have all noted. And I don't know, till the time the sensibilities change and there is a concrete effort on numerous counts, I don't see these things changing.
Yeah, I mean, the response of the state has been definitely very unfortunate. And, if we examine the recent cases of this year itself, in January, we see, in Ahmedabad, Kishan Bharwad was murdered over a objectionable Facebook post, which, again, it was alleged that it was hurting religious sentiments. And then before that, we had the case of, Anurag Poddar of Munger in Bihar. And then the killing of Ankit Sharma in, the 2020 Delhi riots, who was an IB staffer. I mean, a state official being killed this way. So clearly, there is a pattern in these killings, and they are being carried out by a specific group which claims that their religious sentiments are being hurt. How do you see going forward, how do you see the state should approach this subject? Because if we continue to follow the approach as, of the section 295A, that means we follow a consequential kind of reasoning, that we see the consequence of the act and don't link and don't focus on the responsibility, unless you can draw a clear link between the act and the expression. I mean, so there's a clear, problem in the approach that is being taken by the government as well as, the courts. So how do you see we should approach this subject going forward? Because all these killings, they have been happening, and still the prosecution has been very slow. The response from the state has been very slow. It has failed in protecting people. It has failed in bringing the perpetrators to justice as well. So it's a very, very serious subject.
See, first, we need to understand what the problem is. The problem is that, as you said, that the law itself, that is the text, and also the approach of the court, is to adopt the consequence test. So I guess we have zeroed down on the first problem. As far as the consequence test is concerned, why we say that it's a highly problematic test is because it rewards the heckler's veto. It rewards the intolerant, and it almost punishes the tolerant. To make the religious sensibilities of different religions, or to make the sensibilities of any people, not just religions, they may associate themselves with anything. There may be groups on the basis of ethnic minorities or races or this, that, and other. Merely because the tolerance level of different groups differs, the said difference in tolerance levels cannot form the basis of the degree of free speech that I exercise against these groups. The degree of free speech has to be consistent. It cannot be that Durga being called a prostitute, or during the CAA riots, or being shown in a burqa, or the holy symbol of swastik being desecrated in the name of CAA protests, is taken on the chin by a community, and there are no reactions and there are no prosecutions also. Merely because these communities are very tolerant. And on the other hand, even a fair comment or a fair description of history is taken as the ultimate offense against Islam, and it leads to a public order situation, and thereafter, if the state fails in prosecuting, it leads to an extrajudicial killing. So the role of the state, and especially a constitutionally established state, in such situations is based, according to me, on three factors. One are the two P's, that is public order and prosecution. Obviously, the state, while discussing the religious sensibilities, has to ensure that there is public order. Merely because 1 lakh people gathered against Kamlesh Tiwari, it is not the case that the state could not have regulated public order in those situations. The state could have very easily enforced 144A and should have ensured that this reaction is unfair. The first comment was made by the Samajwadi Party leader, and there is absolutely no right for these communities to protest like this. Two is prosecution. Prosecution is important on two folds. One is that you have to ensure that when the first derogatory comment is made, that is by the Samajwadi Party leader, that is prosecuted. And secondly, when finally the violence takes place, or when the public order issue is taking place, even under 144A, prosecutions take place. People are held accountable for destroying public property. People are held accountable for what they say. People are held accountable, obviously, for the violence that take place. And these cases are pursued sincerely by the state, and they are punished by the state. Unfortunately, I think on both grounds, at least in most of the modern cases, I can't comment on the state of Gujarat because it's very recent, but previously, at least in 2015, the state of UP has completely failed on that count. The last point on this, according to me, is a function of both the public order issue and the prosecution issue, is the issue of conditioning. According to me, if swift and severe prosecution and public order issues are taken up by the state, it will certainly have a deterrent effect. This deterrent effect will ensure that there is a conditioning. It is this conditioning of the community that is required. It is not the severity of punishment that the state adopts that leads to a deterrence effect, or it will lead to a conditioning of the community. It is the surety of the punishment. Therefore, it is extremely important that whenever such a religious gathering takes place, which refers to Sar Tan Se Juda, or whenever any kind of socio-religious organization in the nature of, say, PFI or other Chudbaiya organizations linked with PFI across the country are indulging in such instigatory activities, they are taken care of by the state. They ensure that there is surety of punishment. This is where the aspect of conditioning comes in. If these people are punished at the root itself, where they sow the seeds of hatred, these reactions do not come themselves naturally. These reactions come because the seeds of hatred are actually far deep rooted. These seeds are not necessarily rooted in the same manner in different communities. I take you back to the argument of the government advocate in the Rajpal case, that because of the fanatical nature of the community, a different standard under 153A should be adopted. I say that it is the responsibility of the state to ensure that no community has a fanatical outlook, to ensure that such incidents don't take place, and to ensure that there is peaceful coexistence between communities. So the third aspect is conditioning. First, public order, prosecution, conditioning. If these three aspects are done, according to me, things may change. Otherwise, we go by the old maxim that history repeats itself.
Absolutely. And the ideas that you've highlighted, I mean, they should, formulate like the basis of the legal system as well as the response of the government in most of these cases. And, just to reiterate, like the judgment given by Justice Dalip Singh, I mean, it was very much in line with the liberal political tradition, and there are many academics who champion the cause of free speech in this country, but they don't ever recall the judgment given by Justice Dalip Singh, and they completely ignore this foundational principle of responsibility. So I hope that
I will give a loaded statement here, which I think you will certainly understand, that people who always seek to shock, offend, and disturb were the first ones who wanted to mute Sudarshan TV.
Exactly. We hope that the governments do take account of the seriousness of the matter and bring the perpetrators to justice, because these cases have been happening too often, and they are sometimes forgotten by the media, not pursued by the media, and not talked about enough. So thank you so much for raising these issues and for taking out the time to talk to us. Namaste.
Namaskar.